family that we serve. And we serve whistleblowers in 4 ways. The first is that we defend them against retaliation. We do this from everything from informal remedial investigations to due process hearings and trials up to court appeals all the way to the Supreme Court. The second thing that we do to help whistleblowers is help them make a difference. Very frequently, the struggle for survival against retaliation is so intense that it drowns out the point of the dissent, which is no coincidence. Further, whistleblowers can't do too well if they're isolated. They have to have solidarity. So we open up supporting investigations to kind of turn the initial pebble of the truth into a landslide that can't be stopped. And that's a major part of our work, is helping whistleblowers have an impact. The third thing that we do is, Julie previewed, is relentlessly work to get stronger free speech rights, protecting the folks who stick their neck out to challenge abuses of power. And I'll go into a current project in a few minutes. And finally, we share our lessons learned. Besides teaching a law school clinic, we put out survival guides, books, publications, law review articles, do studies. We just finished a study of all the world's whistleblower laws with the International Bar Association. And if you go to the resources pages at our website, this stuff is all free. How to work with Congress, how to work with the media, with other NGOs, www.whistleblower.org. There's a resources page and it's all there for you. I'd like to now just turn for a second to one of the new services that our organization has to help you folks. That's really grew out of this invitation for a Right to Know conference. Elaine Norman just has joined the Government Accountability Project community. Elaine is a 20-year Foreign Service officer who had specialized in rule of law and environmental security projects. And he kind of came to GAP recruiting us to have this event. His connection with us is that he had worked supervising and teaming up with our organization's senior international litigator, Thad Geyer, for a long time. And in particular, they had teamed up when Thad was with the ABA International Justice Project at The Hague in connection with the war crimes. The reason I'm bringing this up now is that Elaine has joined us as a senior fellow. He's available kind of as a personal hotline for confidential discussions. If you want to go over the facts of life, what are your options, consider trying to get more help from our organization, he's here for you. His email address, which I'll put in the chat room, is Elaine N, capital A-L-A-I-N, capital N, @whistleblower.org. And we hope you'll take advantage of this new resource that we're excited about in our organization. The last thing that I want to do is tell you about an opportunity that's in the wings and trying to recruit you to help us get it. One of the things that I've learned about in preparing for this event is that Foreign Service officers have a due process loophole in terms of their anti-retaliation rights when they blow the whistle. You can go to the Office of Special Counsel, but neither they nor OSC can enforce those rights if the Merit Systems Protection Board. And we want to end that loophole so that you folks have the same rights as all other civil service employees, all other government employees at the federal level. And so we're pushing in a meeting tomorrow with the House Committee on Oversight and Reform to add that provision to legislation that's entitled the Whistleblower Protection Improvement Act. And this is also embedded as a subset of the Protecting America's Democracy Act. So it has complete support of leadership in the House of Representatives. And this bill kind of finishes, I'm sorry? This bill kind of finishes the work of the Whistleblower Protection Enhancement Act of 2012. It would give all those who are covered, hopefully that will include you folks, not just an administrative due process hearing, but access to court with a jury trial to defend their rights. It will protect them against retaliatory investigations, and protect you against retaliatory investigations, which military service members have rights against all corporate and contractor workers, but not federal workers. You'll get a realistic chance for temporary relief, which is essential in these cases, can go 5 or over a decade in one that that's been handling. It strengthens the channels for communications with Congress, giving these best practice rights for all communications with Congress, not just whistleblowing. It adds teeth to the Lloyd LaFollette Act of 1912. It tightens up confidentiality protections, which were badly abused during the impeachment process, so that you have to protect not only identities, but identifying information and provide advance notice if it's going to be necessary to out the whistleblower for non-discretionary reasons. It restores the ability to blow the whistle on offices of Inspector General through normal WPA channels. Right now, those are all shunted off to a group called Seide, which basically shields IGs from accountability. It closes the loophole for public health service employees, NOAA employees, strengthens remedies so that if you win your case, you're actually made whole. Right now, under the law, if you're out of work for 10 years and didn't get any promotions, that's considered speculative, not on the table. It'll provide attorney fees for representing whistleblowers in court, which would be good for Afsa's work when you have to go to court. Due process rights for individual employees challenging gag orders. Right now, that can only be done through the Office of Special Counsel, and they can't keep up with them. And if we do get you into the Merit Systems Protection Board, it would say that an administrative judge can't hear your case unless they've been certified in training in the Whistleblower Protection Act. This is a major opportunity for the United States to lead the world again in free speech rights where they count the most. You better believe that I'll be bugging you folks to help us achieve that victory. I've been talking to you about what GAP does and what the law could be. Now we're going to go to something that's a little bit more pessimistic. David Seide is going to be describing to you what your legal rights are currently.
Thank you very much, Tom. David?
Thanks, Tom, and thanks, Julie. I am here to talk about nuts and bolts of the federal whistleblower patchwork, as we call it, framework. So to begin with, know that there are a bunch of laws. Some of them overlap, some of them involve the same and similar principles. And my objective is to show you a bunch of these laws, a bunch of your rights, a bunch of avenues you have as a whistleblower, with obviously a particular focus on FSOs. Raeka, who's going to follow me, is going to get more into the FAM than I am, but know that it's kind of like the same wine, just a different bottle in terms of the principles involved. And so to facilitate this, we've put together a little PowerPoint that I'm hopefully going to share with you guys now. Let me know if it hasn't popped up. So to begin with, here is, give me 1 second. To begin with, here's what we're going to cover today. I'm going to follow up on what Tom has talked about to give you a little more sense about the Government Accountability Project, how we work, what our methodology is, a quick run through of some of our history and latest cases. Then I'm going to get into the actual federal whistleblower laws and the rights and remedies available under them. And then we're going to talk about specific avenues that exist for federal employees in being a whistleblower there, and you'll see there are a variety of things that an employee can do, including FSOs. Then we're going to run through. I'm going to run through a couple of quick examples of how this works for whistleblowers in real life, in real time, and then we'll end up with sort of a page of whistleblower resources and our contact info. So with all that in mind, let me start out to tell you, and this is going to reiterate what Tom has said. We've been around a long time, since our roots date back to at least the 70s. We hold whistleblowers. So as Tom said, we've represented 8,000 folks, and we represent many at the moment. We present their concerns to public officials, advocacy groups, journalists. We obviously also represent them if and when they suffer reprisals for their whistleblowing activities. And we advance legal reforms along the lines that Tom talked about to improve the whistleblower framework. So how do we do that? Well, in a bunch of different ways, and the boxes here reflect that. So first off, we're lawyers, and so we provide, and we're a law firm, and so there's an attorney-client privilege that exists between us and our individual clients. So I have individual cases. We enter into standard legal services agreements or retainer agreements. Now, because we're a nonprofit and are funded primarily through contributions, virtually all our work is done on a pro bono basis. And so know that we're here. We're here to provide answers. You're not going to be, in 98% of the cases, there's no cost to you of any kind. So with all that in mind, what do we do as lawyers in this space? Well, we can file complaints, and the complaints really fall into two big categories. Category number one involves situations where you, as the employee, have witnessed or are aware of something that we'll call it bad. We'll get into the granularity in a minute, but we're talking about misconduct, illegal activity, things that should be reported. We represent you as in a lawyer-client relationship to report those bad things to authorities. It doesn't require any retaliation, anything bad to happen to the particular employee, but we call those kind of cases our disclosure cases. And we represent people before the Congress at hearings, before the OIG, simply to sort of shine light on bad misconduct going on within a particular agency. The other piece of our lawyering, though, involves cases where there is retaliation, where somebody has blown the whistle and is retaliated against in explicit ways, like termination, demotion, suspension, or denial of promotion, or adverse working conditions. So there's a variety of retaliatory things that are involved, and there are various avenues that folks have. If now in the FSO world, one has to go through the State Department grievance process, and Raeka will elaborate on that. If you're a GS or federal employee or a contractor, you have rights before the Inspector General. You can also go to the U.S. Office of Special Counsel, and you can go to the Merit Systems Protection Board. The rights and authorities vary, but just know that we do all that. And we also go to federal court to represent folks as well. The issue is, in terms of the way that the system is set up, typically federal employees have to exhaust their administrative remedies in front of the OIG, in front of the MSPB, the U.S. Office of Special Counsel, and the like, before you're allowed to go to federal court. But we go to federal court, and over the years, we represent people at all levels through the Supreme Court on matters. So above and beyond our legal work, our sort of strict legal work, we engage in what we call media outreach, media campaigns, where we ally with similarly situated groups who might be concerned about issues. So, for instance, at the moment, for instance, Voice of America, U.S. Agency for Global Media, is under, to put it nicely, a lot of strain because of political management who have been doing what we consider to be radical and illegal activities. Well, among the things we're doing, and we're very active in that particular area, is we ally with, say, the Reporters Committee for Freedom of the Press, the ACLU, and other groups who are also concerned to bring these issues to bear, to shine an even brighter light on the issues. So that gives you a sense of how we work and what we do. And now here's just a little sampling of our cases. So as I said, our roots date back really at least as early as the Pentagon Papers and Daniel Ellsberg. but let me fast forward to what we've done in the last year or so. We represent many Department of Homeland Security employees who have been caught up in what I'll just generally call the immigration mess. So we're talking about asylum officers, refugee officers, ICE officers, Customs and Border Patrol officers who have been, obliged to enforce policies they don't agree with. And so, for instance, in this one of our clients was an asylum officer who quit his job rather than enforce Trump administration policies that he considered to be illegal. And so this received sort of considerable coverage in the New York Times. If you're a This American Life fan, they did an episode on his situation, which won the first Pulitzer Prize by any podcaster that was awarded last year for his story. More recently, we're representing folks who are working in DHS detention centers involving the involuntary sterilization of immigrants or detainees in those facilities. Other matters that of late, while we represent many DOJ current and former employees involving investigations that have been quashed or have been stopped by DOJ. That involves, say, the Tamir Rice case, and more relevant, germane to you all, is we've been very active in representing current and former VOA and USAGM employees and the other agencies like Radio Free Europe, Radio Free Asia, in a variety of fora, but in particular, we represented a number of people before the House Foreign Affairs Committee when they testified at the end of July. So, so as you can see, we do a lot of, we're involved in a lot of different areas. We also do private sector, and we represent private sector employees under the Sarbanes-Oxley laws. I'm not going to talk much about that. We also represent federal contractors as well. So, so now we're going to turn to the actual whistleblowers laws and the substance of them. And so the sort of the guts of the federal whistleblower laws is under the Federal Whistleblower Protection Act of 1989. There was an enhancement act that has followed on to that. But the basic principles are the following. The law prohibits retaliation against an employee who discloses information they, the employee, reasonably believe to be, and these are the categories of that an employee can report that fall within the federal whistleblower framework. And just per what we were talking about vis-a-vis disclosures, each one of these categories of disclosures is considered a protected disclosure within the federal whistleblower laws. And if any adverse action is taken by an agency against someone who's so reported, that's a prohibited activity, and the employee has remedies in law. Say they can be say they can collect back pay, they can collect attorney's fees. We're going through this process. And equity, they can have their jobs restored if they're so interested. So with all that in mind, let me just roll through the 5 categories you see on your screen. Number 1, an employee can report a violation of law, rule, or regulation. So obviously we're talking about statutory violations, but this also reaches in the FAM and violations of that. It also reaches formal regulations that have been promulgated. And it's fair to say that this current administration has crossed the line in a variety of those spaces. The next category, though, involves gross mismanagement or gross waste of funds. So what are we talking about? We're not talking about just plain old mismanagement or negligence or day-to-day things. We're talking about what I like to think of as things that are beyond the pale or particularly noticeable. And frankly, a lot of this are judgment calls. And we're here, GAP, are here, and Afsa is here to answer your questions when you have them about whether something is or isn't considered gross mismanagement or gross waste of funds. So don't feel like this is a judgment you may have to make on your own, because you don't. The third category that we have here is abuse of authority, and the way we think about that is something like this. Now, pursuant to, say, the FAM, there's plenty of guidance that's provided by the department as to how protocols and procedures should be followed in terms of who needs to approve things, who needs to sign off on things, what needs to be vetted, all the procedural stuff that you all live with day in and day out. The issue is, though, is that if, say, management ignores those protocols, decides instead of following the 5 steps required under the FAM or the memo that the chief of mission has issued providing direction, that is a breach of procedures, which in our world, we define that as arbitrary action by an agency leadership. So if the agency, let's just talk about, say, good email practices. If say just to use a hypothetical close to my heart, say the chief of mission starts using his or her personal email account for department business. Well, that's prohibited under the FAM. Whether it's a violation of law or not is debatable. But the bottom line is that's a breach of protocol. That's an arbitrary action by the chief of mission. And we deem that, as a matter of law, to be an abuse of authority. And so that's a reportable protected disclosure that we often see in May. The other categories are a substantial and specific danger to public health and safety. That covers a broad array of matters, but it can be as simple as your manager or the agency official says don't wear masks in a closed room. Well, that is from my point of view, endangering the people in the room who are not allowed to take appropriate precautions during the pandemic. There's a whole range of things, and so we define public health and safety down to the individual level. It doesn't necessarily just have to be a whole group, but so know that's there. And finally, censorship's an issue. This specifically applies in scientific cases or involving research analysis. It's obviously germane in settings like HHS, NIH, and the like, but obviously the department has, department's missions reach this as well, so just know that it's there. So let's go on a little bit. I've talked about what a protected disclosure is, and these are the specific agencies within the federal government that if an employee makes a disclosure to any of these agencies, it's and retaliated against, that's what is called a prohibited personnel practice. So that includes the U.S. Office of Special Counsel. That's an independent federal agency that was set up to represent whistleblowers and does represent whistleblowers across a variety of topics. The other areas that disclosures can be made for which there's protection includes the Office of Inspector General, the agents in all offices, all large agencies, especially state. There's a variety of offices that are authorized to receive disclosures of protected disclosures. So that would include L. It likely includes people in the Director General's office. Just know that, in other words, know that there's no one particular office that or person you need to contact. Further, you can reach out to agency management. It can be your immediate manager. It could be another manager. It doesn't have to be within your chain of command. It has to be someone who has authority to do something about the problem you've identified. So in my email example, if if an employee was to reach out to, say, the head of information management to notify them that the chief of mission isn't following protocols on email uses, that's likely a protected disclosure. And finally, and importantly for the work we do, is Congress. So by law, Congress is an authorized recipient of the kinds of disclosures we talk about. And therefore, it's difficult, if not impossible, for agencies to take action against employees who report to Congress. But there are exceptions and limitations, such as there may be limitations, for instance, on national security material and that can be disclosed. So no, there are limitations, but these are venues that exist. So let's go on to another sort of some practice points in this space. In terms of the wrongdoing that needs to be reported, the employee doesn't have to prove that it's actually wrong. In other words, the employee doesn't have to know that this is a violation of law as much as the employee has to have a reasonable belief that the concern is true. So it may well come to pass that the employee reasonably believed that was gross mismanagement. Turns out that down the line, the agency shows it's not gross mismanagement, it's just plain old mismanagement or no mismanagement at all. Well, that doesn't take away the protections the employee has, especially if the employee has been retaliated against. So just know that's there. Another point that comes up a lot is, well, what if the employee has an axe to grind, and that's why they're reporting. The bottom line is motive doesn't matter. Anyone can report. This issue comes up, though, in terms of figuring, when the people receiving the report are going to figure out, well, is there real substance to this or not? They may want to discount a witness's credibility if in fact they're biased in their presentation. On the other hand, facts are facts. I like to say that a broken clock is right twice a day. And if that's what it is, that's what it is. And I've already mentioned the third practice point, that you don't have to go through your immediate chain of command. So there's also a specific provision that reaches federal contractors. So for those who deal with contractors, as you do day to day, know that they have the same kind of rights, same kind of categories. There are limitations on where they can go. So they, for instance, cannot apply to the U.S. Office of Special Counsel, but they can go to the OIG, which fields these requests. They're not, the statute is currently drafted, doesn't reach scientific censorship, but by and large, it's within sort of the same zone as I've just discussed. And they also have rights in federal court. That's why they're mentioned here. So let's go to a little more specificity on the specific avenues that whistleblowers have. So to start off with, I don't view these as in any particular rank order, but know that state OIG, for instance, and all the other OIGs have whistleblower offices, and the one I have up here is for Department of Homeland Security. If you go to the OIG page for Department of State, you'll see there's a whistleblower tab. If you click on it, you'll be taken to a page where you can file a complaint, and the complaint can be filed anonymously, where you're not identified. So to the extent you're worried about putting a target on your back or retaliation, that need not happen. And frankly, just to come back to what we do at GAP, we work individually with each and every client, and there are mechanisms available to protect your identity from disclosure to the agency, or frankly from virtually anyone else. And in our experience, those, while we don't provide guarantees of anonymity, our experience is they work to some degree. And especially in early parts of matters, that becomes quite germane. So just know that they're there, and know that the various offices that receive this information handle it. Now, in the OIG world, for instance, at state OIG, there's a whistleblower coordinator who does trainings like this. He fields complaints like this, and he makes referrals within OIG where he finds matters to be investigated. OIG also has a hotline. You don't have to deal with the whistleblower office at all. You can place a call and act anonymously and report whatever you wish to report, and that's just another intake mechanism for OIGs. So let me go to the next. Let me go back one. Let me go back to the next avenue, which is the U.S. Office of Special Counsel. Now, for Foreign Service officers, this is a valuable avenue, but it's incomplete. So let me talk about why it's valuable. To begin with, think of OSC as sort of a separate investigative agency that will pursue allegations of misconduct. And they're not especially different in that respect from, say, state OIG, that if a report of misconduct is received, OIG can and should investigate the matter. But these offices get a lot of referrals, a lot of info, and sometimes they have trouble figuring out which case to work on and which one not to work on. And it may come to pass that, say, state OIG is doing nothing with the case, or given the state of state OIG, in terms, obviously there's been a lot of turnover there lately. Perhaps they're not as active as they could or should be, given current circumstances. So this is a long-winded way of saying you have a variety of avenues to pursue, and what both OIG and OSC can do is they can write reports that essentially shine a spotlight on the problem. And it's less about, say, disciplining a senior manager for, improperly terminating an employee who's blown a whistle, as much as the fact that the OIG or OSC can issue a lengthy, detailed report, which likely will and does get picked up by members of Congress, the Oversight and Appropriations Committees in particular, who may wish to and do hold hearings on the subject, which in turn leads to additional media attention, which in turn may have an effect on agency policies and procedures, because the agencies I work with don't like bad publicity, and this is bad publicity. So in fact, putting the OIG or the OSC into the mix may in and of itself have a deterrent effect. So let me talk about the limitations on the OSC in particular, and that involves claims of retaliation. OSC for FSOs does not handle retaliation claims. So OSC would be involved on what I've called a disclosure case. They would pursue that. But to the extent one has been retaliated against as an FSO, one would go to the Foreign Service Grievance Board. On the other hand, if you're a federal contractor, if you're a GS employee, you can go to OSC. And OSC findings and orders of retaliation are enforced. There's a sort of an appellate organization called the Merit Systems Protection Board. It's that's in place to impose remedies to help employees who are wrongly afflicted with prohibited personnel actions. But MSPB is not available to FSOs, and so just keep that in mind. So let me turn to another avenue, and that's the Congress. And they, depending on which committee, which house we're talking about, play very active roles in these spaces, because they're interested in getting reports of misconduct and shining lights on it. So, for instance, this is a hearing after the DHS employee, the asylum officer, disclosed that he had quit based on his opposition to Trump administration asylum policies. The hearings were held where he testified on these issues. So, in other words, it's a useful, valuable tool that members of Congress pursue. Obviously, these days, the notion that Congress is going to pass a law, saying cut it out is the likelihood of that has been low, and I don't think it's going to improve all that much given the current composition of the Congress. But Congress has a powerful tool, which is its powers of investigation, and so so particularly on the House side in the last several years, they've been very active. But frankly, the Senate's involved as well, just in terms of, say, what's been going on at the U.S. Agency for Global Media. It's really been a bipartisan expression of concern across the board in both houses of Congress. So those are the four avenues that I've talked about today. Now I'm gonna roll through an example of something fair, a recent example. This involves Rick Bright, who was fired from his role at Health and Human Services after he raised doubts about the efficacy of using hydroxychloroquine to treat COVID-19. Go figure. So what did he do as a whistleblower once that happened? Well, first off, he went to the U.S. Office of Special Counsel, and that's the website we saw earlier on. There's a form you fill out there. It's called, it's a Form 14 for those who care about numbers. And so the form is filled out, but more importantly, he hired a law firm, or a law firm began to represent him. Likely, I don't know the details particular, but I'd assume this was done on a pro bono basis. And what the lawyers do, and what we do at GAP, is we work with you, the whistleblower, to prepare detailed factual summaries that essentially explain to someone who knows nothing about the topic, and that's usually the people who work at all these reporting agencies, who the person is, what the topic is, what the issues are, why the issues are important, and what somebody should do about it. And so and our addendums can range in size from 5 to 50 single space pages. Obviously, we simplify it and make it as user friendly as possible, because there's no benefit if you're lost in the details of it. But we do this day in and day out, so just know we're providing that kind of value to whistleblowers. So in this case, for instance, Dr. Bright provided his complaint form and the addendum, and this is sort of a highlight of it. So I've just quoted here that he was removed as director because of his efforts to prioritize science and safety. Not exactly radical notions. He exposed practices that pose a substantial risk to public health and safety, protected disclosure of the kind we're talking about, and it rankled those in the administration, leading to the adverse employment action. So what does the Office of Special Counsel do when they get something like that? Well, let's just take the disclosure route to begin with. If the Office of Special Counsel determine, and this is a different case, but I just want to give you a sense of what the procedures are. If the Office of Special Counsel determines that that Dr. Bright's case has merit, and they do that by doing their own internal due diligence research, they have their own lawyers on staff and investigators to figure this out. What they will do is send a letter to the agency making this finding. It's circled here. That the letter will say, I, meaning the special counsel, that's a presidentially appointed Senate confirmed person, has concluded there is a, quote, substantial likelihood that the information provided constitutes, and it falls into those categories I just talked about: gross mismanagement, abuse of authority, violation of law, rule, or regulation. Now, under the statute, the way this works, and we'll get to this in a second, is the agency has a right to respond to that. But what the value is from a whistleblower advocacy perspective is that this letter can then be used and is typically entered into the public domain to demonstrate that a third party, a neutral third party, has made an independent judgment that there's a substantial likelihood of misconduct. And I view this letter as not dissimilar from, say, an OIG report that doesn't necessarily discipline the agency, but says the agency's, messed up in the following 6 ways, and that's really bad. Well, the same thing happens here. I think of the OSC report and letters as an OIG report on steroids, and it provides so it's an additional venue to be pursued. Keep in mind, though, that because the resources of all these agencies are limited, they typically divide up the universe in terms of whistleblower complaints. So what, as a matter of practice, if nothing else, OSC will typically not work on a matter that's before OIG and vice versa. In fact, the form that one fills out has a little box that you have to check yes or no as to whether or not you've filed with OIG the same complaint. Largely, this comes down to judgment calls that individuals make, and again, that's what we're here for. We're here to provide insight, perspective on these issues as to what's appropriate and why. So let's assume that the letter goes in. The agency is then given time to respond. Now, by statute, the agency is supposed to respond with a written report within 60 days. In fact, in the real world, they get more than 60 days because it takes time. This report that we're looking at, which was a response to the letter I just showed you, took about a year to prepare. What's important about it for our purposes is that once the report comes in, the Office of Special Counsel does its own assessment of whether it believes it or not. And in this case, for instance, it decided or determined that the agency's written response was unreasonable. And what happens on a protocol procedural level is that OSC sends that conclusion to the Congress, the oversight agencies, and to the president. And this letter enters the public domain. So to the extent, from a pure sort of media strategy point of view, you get at least 2 bites of the apple if the agency's already been called on the misconduct to begin with by OSC, and then the agency comes back and provides specious excuses that are rejected. OSC gets to weigh in on that in a very public way. And what OSC then does is they publish all their materials on their website. So all of the material enters the public domain. What I'm talking about are the complaints, the letters that OSC sends, the agency response, OSC's response to that. The whistleblowers are permitted to have comments on this as well. So know that there's a fairly elaborate procedure available, and that's not the case with OIG. OIG follows similar protocols in that if they get a referral and decide to investigate the case, they may or may not elect to issue a written report. If they do issue a report, they're likely going to let the agency have, inevitably, or in my experience, the agency is going to be permitted to review the report and provide comments, to which OIG will then respond to. At the end of the day, it's similar to OSC, but it's just it's a somewhat different process. So that in a nutshell is sort of the examples we have that I've put together for today. So I'm going to wind up here with what available resources that are available. And this is what Tom's alluded to. And so at the bottom is our sort of whistleblower address, website. These are 4 recent guides we've put together for whistleblowers. There's loads of other links and materials for you to view as well. And finally, and I apologize to Elaine for not having his name on this last slide, but here's the contact information for Tom and me. I assume we're going to keep this, we'll provide that to you all in hard copy if you need it or want it. But the simple way to find us is our emails addresses are our first names and the initial of our last name. So in my case, it's David Seide, which is David S at whistleblower.org. In Tom's case, and there's a typo on this, it should be Tom D at whistleblower.org. And for Elaine, I assume it's going to be Elaine N at whistleblower.org. And on the right is our telephone number and our website address. So I've taken up a lot of your time. I hope this has been of some value to you, and happy to answer questions. Thank you.
Thank you very much, David. We'll now go to Raeka to talk about Afsa's role in the whistleblower protections. Raeka?
Sure. Thank you, Julie. And I will keep it quick so that we have time for questions. Let me just pull up. And I apologize, it was quiet over here and just now a car alarm went off. But there we go. Okay, so you guys should have that up on your screen now. I was going to briefly go into what it is that Afsa does, but as Afsa members, I believe that you guys are familiar with this. If you have any questions, you could always reach out to us at afsa@state.gov. So I will jump past that and go to the heart of the presentation today. The standards and the protection that David laid out earlier, those apply to all federal employees, civil service or foreign service, but I share this as this provision in the Foreign Service Act, which is section 105, is the language that explicitly applies to the foreign service. The text is the same as the civil service counterpart that David mentioned in Title V of the US Code. So you have that, the standards are all the same. David went through those. According to the Whistle Protection Enhancement Act of 2012, all the inspector generals are to name what's called a whistleblower protection ombudsman or coordinator. And so for our agencies that have the foreign affairs component, you'll see the list contact information for those ombudsmen and coordinators. Julie will have this up on our Afsa website, and so you'll have access to this as well as the contact information that David shared earlier. Moving on, David spoke to you about the options available for those who wish to file a complaint. The OIG and the OSC are available to the Foreign Service, and obviously going to Congress is something that is available. But I did want to go into the grievance route, which is where Afsa steps in and can help our members. And so as you see on your screen, the provision is 3 FAM 4412. And this is where you'll see the list of grounds under which a person can file a grievance. And you'll see in the list that there's several adverse actions that could be the result of retaliation. So for example, you have wrongful disciplinary action, dissatisfaction with the work environment, and probably what we see most commonly is omissions and errors or falsely prejudicial information in your OPF. And that typically is an EER where a rater or reviewer in retaliation has made some comments in there that are false or inaccurate. So as a member, if you've suffered one or more of these adverse actions and you believe that it's because of your status as a whistleblower, you do have the option to file a grievance. The grievance process contains 2 steps. The first is an initial grievance that you would file with the agency. After that, depending on the outcome of your grievance, if it's necessary, you can file an appeal with the Foreign Service Grievance Board. And that would be the Foreign Service equivalent to what David had mentioned earlier, which is the MSPB. And so that would be the final administrative level in the grievance process. The one thing to keep in mind is that you can file with the OIG or the OSC. As David has mentioned, you could get a report from them, and then you could bring that report and file a grievance. So since the OSC doesn't have any enforcement authority, they would just issue their findings. You could then bring that and use it as evidence of retaliation when you file a grievance. The one thing to keep in mind is that you can't necessarily do it in the reverse order. And what that means is that you can't participate in the grievance process, appeal a decision to the grievance board, and then if you're not successful, go back and file with the OSC. So something to keep in mind. It is pretty convoluted. So my suggestion is that if you are considering multiple avenues of relief, feel free to reach out to AFSA or to GAP and we could walk you through that. And before we turn to the questions, the one thing that I did want to mention is that when determining whether or not the grievance option is the right one for you, the question to ask yourself is, what is the remedy that you're seeking? And so in the grievance process, the available remedies are those intended to make the person whole. What that means, said differently, is to put you in the position you would have been had the retaliatory conduct never occurred. And so whether it be a rescission of a disciplinary letter that was placed in your OPF, whether it's redacting inaccurate portions of an EER or removing the whole EER from your file, and then as a result, requesting a reconvened board to review the corrected OPF, for example, for promotion or tenure. What you cannot get through the grievance process is what we refer to as punitive damages, which means you can't seek money for any emotional distress that you suffered. You can't seek to punish the offender, the individual that carried out the retaliatory conduct. So those are things to keep in mind when determining if you would like to pursue the grievance route. And again, AFSA is here to walk you through the process, so always feel free to reach out to us. And I apologize, I went quick with that, but I wanted to make sure that we had time to answer your questions. So feel free to answer, or feel free to ask any questions you have. Thank you.
Thank you, Raeka. I'll read out some questions that we have gotten so far, and I'm going to go over the three of them just to give you some idea for the speakers to determine who would answer which. The first question is about Masha Jovanovic, Ambassador Jovanovic. And it's a question that says, during the congressional impeachment investigation of President Trump, according to Jeffrey Toobin's new book, True Crimes and Misdemeanors, the administration's legal team wrote a letter instructing all executive branch employees, including those at the State Department, to refuse to participate in the impeachment investigation. Later, a State Department official instructed Ambassador Jovanovic not to give any voluntary testimony to the investigation. Her lawyer pointed out that a subpoena would compel her to testify since it is no longer voluntary. And of course, she did end up testifying. Question: can a presidential administration legally prohibit a career Foreign Service employee from providing testimony to Congress? Did Ambassador Jovanovic break any laws? And the second one is, could you describe some current avenues to report misconduct by DS and OIG? They appear to be not subject to any limits on their authority. The third is, could you give specific examples of retaliation in the Foreign Service context? Is not being promoted, for example, an example of retaliation? Or not given opportunities, sorry. Wanted to add that.
I'll take the first question and bow out on the next two, but it's absolutely illegal on the order not to testify in Congress, to refuse to participate or do anything voluntary. That was the legislative outcome of the Afsa v. Garfinkel suit. In fact, there's been an appropriations rider since FY 1988. It says it's illegal to spend any funds to implement or enforce a non-disclosure policy or agreement, but a policy as well that would cancel your rights under the Whistleblower Protection Act. And this does that exactly. And it also makes it illegal to spend any funds to enforce a policy that would interfere with communications with Congress. There's another appropriations rider which says that the salary of anybody who tries to pull those shenanigans can be canceled. It's very hard to enforce, but it's a good threat. And it's a cornerstone of the Whistleblower Protection Act rights we'd like to get you folks fully enfranchised in. And just as sort of a PS to this, I wanted to add a few pieces of meat to the bones of our presentation that I think will make a difference for folks. The scope of your rights. On violation of law, you're protected for disclosing violation of any law, rule, or regulation. It can be a state or local law, and it can be illegality by, say, the target of a report of investigation, a corporate actor, a private sector actor. It's not just government misconduct. Second, a concept called duty speech. Your rights aren't limited to allegations. If you're disclosing protected information that David described, it's part of a memo with policy recommendations. But that memo includes some facts that nobody wants to deal with, so they harass you or try to censor. No, you've got rights under the Whistleblower Protection Act. But there is a qualifier. The retaliation has to be personal. It has to be reprisal, not just a causal link. And that's harder than the other whistleblowing. On national security loopholes, there's some qualifiers on that. One is coming out of this anti-gag statute, that if the information is classified and that's restricting your rights, it has to be marked classified. You don't have to guess as to its status. You're entitled to specific prior notice before those restrictions kick in. And if it's controlled unclassified information, which is 100 categories of that are restricted on national security grounds, but not classified, that doesn't affect your rights under the Whistleblower Protection Act. That's because of Executive Order 13556 that President Obama issued. They're not relevant for your free speech rights. With respect to confidentiality, David was right, the laws are there, but we don't have enforcement capacity for them. And that's met to some pretty treacherous situations when IJs didn't respect those rights. And finally, in terms of GAP's resources, another one that you might want to have on your radar screen is, because you can't count on your confidentiality rights, more effective skills to blow the whistle anonymously. In the book there that we did with two of our co-organizations, Project on Government Oversight and Public Employees for Environmental Responsibility, you can find on the website, is called Caught Between Conscience and Career, Exposing Abuse Without Exposing Your Identity. So that's just a few things to round us out.
I'm happy to take the second.
Sorry, the second question?
Yep. So if I recall correctly, it was what happens if DS or OIG engage in abuse of authority.
Yeah.
So typically if OIG engages in any misconduct, it's DS that would investigate them, and vice versa. If DS engages in any misconduct, then it's OIG that steps in to investigate them. But understanding how bureaucracies work, people do hesitate sometimes to make those allegations to the competing office. However, if the actions of either office fall under the statute that David mentioned, or the Foreign Service Act, which, you know, if there's a violation of any law, rule, or regulation, mismanagement, gross waste of funds, you could always take one of the avenues that we've discussed today. So going to the Office of Special Counsel, taking the grievance route. So those options are available. David, is there anything that you wanted to add?
I'll just chime in a little bit. So in terms of OIG in particular, there's an umbrella organization called the Council of Inspector Generals. It's or Seide as we call it in the trade. They take complaints about OIG misconduct. So above and beyond OSC, which I think is a prudent place to go, especially if both DS and OIG are involved. Also, you do have the congressional route as well. And so, and frankly, our experience is one pursues a bunch of these things. These are not exclusive remedies as much as they are. We try to make them complementary remedies or routes to follow. So I'm happy to try to go to the third point, which is, so if people have been retaliated against for blowing the whistles, short answer is yes, because, and frankly, you know, Afsa probably has a better read on what's happened than I do, but it does happen. It's a fact of life. Now it may be explicit, like you're fired. It can be subtle, like you didn't get that promotion, or you got transferred to a post and an assignment that was your fifth choice, if it was a choice at all. So there are a variety of ways this happens. I mean, that's what we call the risk of being a whistleblower, is that you're putting a target on your back. On the other hand, and we've had a lot of experience the other way here, that our clients of ours who have in fact gone public, in fact, gain immunity in many cases from retaliation. I mean, just for what it's worth, we have a bunch of Department of Justice employees who have bravely stepped forward, have testified before Congress on a variety of matters in the last few months. And frankly, I think their testimony and their role has been applauded across the profession, certainly. And they haven't experienced retaliation, in part because that's just another piece of bad publicity for the agency if they go after someone who's now become visible. So it can cut different ways. And frankly, we deal with this on a very much a case-by-case, individualized basis. So we learn about who are we talking about the agency? What are we talking about? There are plenty of ways in our world to anonymize information, so it isn't inevitable that you are the whistleblower. I mean, especially at a place like state where information is disseminated across multiple offices and bureaus. There are many times, when I was at OIG, I dealt with confidential folk and folks in confidence all the time, and took extra steps to preserve their identity and confidentiality. So just know that's there, and we're happy to be of help.
We have about 3 minutes left.
Okay.
I think I'm going to go to do these protections cover people on details? Since maybe that would be a quick answer.
Yes, they do. And in fact, a retaliatory detail can be challenged under the Whistleblower Protection Act.
Oh, okay. And has any consideration been given to keeping track of repeat offenders who have had multiple successful grievances filed against them? Why doesn't the department, I assume the State Department, at least inform these repeat offenders that the FSGB has decided against them? We have 2 minutes to answer that question, and then we'll close.
It's a very good illustration why you need to get full rights under the Whistleblower Protection Act. And actually under current law, you could make some progress. Something called the Dr. Kirkpatrick Whistleblower Protection Act, passed a few years ago, said that if the Office of Special Counsel finds a prohibited personnel practice, even without merit board enforcement of relief, they just find a prohibited personnel practice, the agency is required for a first offense to propose a 2-day suspension, and for a second offense to propose termination. They're not required to fire the person, but they have to put that cloud over their head and force them to defend themselves against the abuse.
Thank you very much, Tom. That we have 1 minute left, so I think I'm going to close and thank all of our speakers very, very much, and thank everyone who is participating in our audience. Thank you very, very much, everyone, and have a good afternoon.
Thank you.
Thank you.